The A.K. Gopalan judgment initially held that the fundamental rights were mostly separate watertight compartments and that the procedure established by law in Article 21 simply meant any state enacted law without necessarily requiring it to be fair. Subsequent cases gradually eroded this interpretation, leading to a more expansive view of fundamental rights. Kharak Singh versus State of Uttar Pradesh 1962 was one such case. This case stands as a landmark judgment addressing questions pertaining to the right to privacy and the attack by law enforcement agencies on the same. Adjudicated by Supreme Court in 1962, it marked a critical juncture in the interpretation of constitutional rights and balancing them with the needs of the state surveillance. The petitioner, Kharak Singh, in this case challenged aggressive surveillance measures employed by the Uttar Pradesh police as being violative of his rights to privacy. The surveillance methods adopted by the police included secret picketing, domiciliary visits at night, and periodical inquiries. These actions were authorized by the UP police regulations. The Supreme Court provided relief to the petitioner not on the ground that the actions violated his rights to privacy, but on the basis that the person's right to life may only be restricted by law and not by executive order. The case initiated a jurisprudential debate shaping the privacy rights in India, making the case an inception point while tracing the developments of right to privacy from its nascent references to unanimously being held as a fundamental right in the K.S. Puttaswamy case 2018. When this case came up for hearing in the Supreme Court, the then Chief Justice of India, Shri Bhuvneshwar Prasad Sinha, constituted a bench comprising of 6 judges. They were Justice Bhuvneshwar Prasad Sinha, Justice Raj Gopala Iyengar, Justice Zafar Imam Saeed, Justice K. Subba Rao, Justice J. C. Shah, and Justice J. R. Madholkar. The verdict was pronounced on 18th of December 1962. Now, let us look into the facts of the case. Kharak Singh, a petitioner, was a resident of Uttar Pradesh who filed a writ petition in the Supreme Court of India in 1962, challenging the validity of certain surveillance tactics employed under the UP police regulations. Kharak Singh was earlier put on trial for allegedly being part of an armed robbery but was released due to lack of evidence under Section 169 of the Code of Criminal Procedure 1973. The UP police also opened a history sheet defined under Section 228 of the UP police regulations for the petitioners, classifying him under Class A of the criminals under surveillance. Class A was meant for dacoits, burglars, cattle thieves, and railway goods wagon thieves. Meanwhile, Class B was meant for confirmed criminals who were highly likely to commit crimes other than those mentioned above, such as professional cheating. The petitioner had said that the authorities had watched him round the clock. He had said that the village guard and sometimes the cops arrived at his house, had banged and shouted at the petitioner's door, and had disturbed his peace at night. The police also went so far as to make him wake up and take him to the police station to verify his identity. Whenever Kharak Singh travelled to another place, he had to tell the village guard or the police station about his trip. He had to inform the station where he had gone and when he would come back, and as soon as he had reached his destination, the police station at his destination had been informed by the police from where he resided to keep an eye on him in the same exorbitant way. This displayed the intensity of the poking surveillance that Kharak Singh was put under. These acts were carried out under the grab of UP police regulations that were validated by Section 12 of the Police Act 1861. The police were authorized to carry out surveillance, maintain records of the movement and activities of the individuals, and conduct domiciliary visits between 10 p.m. and 6 a.m. without a warrant. Kharak Singh argued that these actions violated his right to privacy, which should be considered a fundamental right protected under Article 19 and Article 21 of the Constitution of India. The petitioner claimed that the surveillance and domiciliary visits not only infringed upon his personal liberty but also affected his right to live with dignity and security. He argued that the police actions were without any reasonable grounds as considered under Article 21 and were conducted solely based on the suspicion or mala fide satisfaction of the police authorities. The state of Uttar Pradesh, represented by the respondents, defended the validity of the Uttar Pradesh police regulations. They contended that the regulations were necessary for the prevention of crime and protection of public safety, thus effectively painting the petitioner as public enemy whose rights can be restricted in favor of the society. Before we consider the issues involved, let us go over to some of the essential provisions of law involved. Article 19 guarantees 6 freedoms to all citizens, including the freedom of speech and expression, freedom to assemble peacefully without arms, to carry on any trade, profession or business, or to form associations or unions, and to move and reside in any part of the country. However, these freedoms are not absolute and are subject to reasonable restrictions, such as the interest of the state and order, public health and morality, or the interest of any marginalized groups in the country. Article 21 ensures the right to life and professional liberty, protects against arbitrary actions, and emphasizes a fair legal procedure for the deprivation of any of the person's rights. Article 21 has been used to expand the ambit of fundamental rights, bringing within its scope more and more rights as what constitutes life and personal liberty. It also provides the judiciary with the option to fine-tune fundamental rights to be in conformity with the changing circumstances and the level of development in the country. Now, let us look into the issues of the case. The main issue while hearing this case before the Honorable Supreme Court of India was to determine whether the surveillance and domiciliary visits carried out by the police under UP police regulations violated fundamental right to privacy guaranteed under Article 21 of the Constitution of India. The specific issue can be further broken down into the following components. The first issue is the right to privacy. The court had to determine whether the right to privacy is encompassed within the broader concept of personal liberty under Article 19 of the Constitution. The constitutionality of surveillance and domiciliary visits was closely linked to the recognition of the right to privacy as a fundamental right. The second issue related to the constitutionality of surveillance. The court had to analyze whether the provisions of UP police regulations, such as classifying them within Class A and Class B of criminals, which authorized surveillance by the police without proper safeguards and other oversight, were in violation to the right to privacy. The issue was whether such surveillance infringed upon an individual's right to privacy and personal liberty. The third issue related to the constitutionality of domiciliary visits. The court needed to assess the validity of domiciliary visits conducted by the police under the UP police regulations, which allowed entry into individual dwellings without warrant at odd hours of the night. The fourth issue related to the standard of justifying surveillance and domiciliary visits. The court had to establish the standards for justifying surveillance and domiciliary visits. It needed to determine whether only or subjective satisfaction of the police authorities were sufficient grounds for such actions, or if there needed to be more objective and reasonable grounds. The fifth issue related to procedural safeguards. The court needed to evaluate whether the UP police regulations provided adequate procedural safeguards against the arbitrary exercise of police powers. The issue was whether there should be a requirement for a warrant and specific objective criteria to ensure that the right to privacy was not unlawfully infringed upon. The decision in the Kharak Singh case not only addressed these specific issues but also laid down the foundational principles that continues to shape the interpretation and protection of right to privacy in India. Now, let us look into the petitioner's arguments. The petitioner's arguments were based on three premises. Number one, violation of fundamental rights to privacy. It was urged before the Supreme Court that the acts set out in Clause A to F of Regulations 236 infringed upon the rights given by Article 19(1)(d), which is to move freely throughout the territory of India. The petitioner argued that along with Article 19, the personal liberty under Article 21 was also shadowed by the acts mentioned above. The petitioner argued that continuous police surveillance and nightly domiciliary visits violated his fundamental right to privacy. He contended that privacy is an essential aspect of personal liberty and dignity, and a compelling state interest must justify an infringement upon it. The second argument was that the police action was arbitrary and unreasonable. The petitioner asserted that the surveillance and domiciliary visits were conducted without any reasonable grounds or objective criteria. He argued that mere suspicion or subjective satisfaction of the police authorities cannot be a valid basis for intruding upon an individual's privacy. He described that the Chowkidar was to report to the police station to report his presence. The petitioner also alleged the misuse of authority by the Chowkidar of the village, going beyond the scope of the instructions given to him. However, this was outrightly denied by the police officials and not taken into consideration by the bench. The basic argument under the head rested on how are minimum requirements of the state to deter crime of having surveillance on habitual criminals, but the UP regulations goes above and beyond those requirements, allowing for a totalitarian arbitrary power by police officials. The third argument was related to the lack of procedural safeguards. The petitioner brought notice to the absence of proper procedural safeguards in the UP police regulations. He asserted that the regulations did not warrant or provide any oversight mechanism for surveillance and domiciliary visits. The police could enter his house without having to follow any of the standard procedures due to the regulations. This lack of procedural safeguards gave wide rooms for the abuse of authority and effectively made it simpler to violate the petitioner's privacy. The respondents' arguments can be divided into two parts. Number one, the UP police regulations do not constitute an infringement on any freedom guaranteed under Part 3 of the Constitution. Number two, even if the regulations do infringe upon the freedoms under Part 3, then such infringement is a reasonable restriction as they were framed to allow the police to act more efficiently to protect the interests of the general public. The regulations so made were only directed towards those. The ratio decidendi, or the legal principle underlying the decision in this case, revolves around the recognition of the right to privacy as a fundamental right under Article 21 of the Constitution of India, and the insistence upon the procedural safeguards and objective standards for limiting this right. The key components of the ratio decidendi can be summarized as follows. Number one, regulations made under Section 12 were not statutory provisions. The regulations permitting classification and extra surveillance on habitual criminals were not valid laws within which the state could make restrictions for Clause 2 to 6 under Article 19. The regulations also do fall under the procedure established by law and thus could not be construed as reasonable restrictions on the life and liberty of an individual as guaranteed by Article 21. The court granted a part writ of mandamus sought by the petitioner directing the UP police not to continue domiciliary visits to Kharak Singh. The second component of ratio decidendi was the domiciliary visits at odd hours employed by UP police were held to be unconstitutional. The court recognized that while the right to privacy is not explicitly mentioned in the Constitution of India, it is implied in the broader concept of autonomy and personal liberty under Article 21. The right of the accused to move freely was also violated due to the need to inform the station wherever he goes. The court held that an individual's right to privacy is essential for preserving personal intimacy, safeguarding one's personality, and leading to a life free from unnecessary interferences. It was highlighted that the term personal liberty is intended to complement the constitutional purpose of ensuring individuals' dignity as expressed in the Constitution's preamble. The third component of ratio decidendi was restricting the right to privacy. The court held that the right to privacy can only be limited if there is a compelling state interest. Mere suspicion or subjective satisfaction of the police authorities cannot be sufficient ground for the infringement upon an individual's privacy. The court further held that neither Article 19D nor Article 21 was being violated through picketing of the petitioner's house, as it was important to keep track of persons' contacts and activities that habitual criminals or those about to become habitual criminals were meant to engage in. The rights granted by the Constitution were not intended to protect mere personal sensitivities. The fourth component of ratio decidendi was regarding procedural safeguards. The court ruled that the UP police regulations, which allowed surveillance and domiciliary visits without proper safeguards, were unconstitutional. The court highlighted the importance of procedural safeguards such as those requirements of a warrant and objective criteria for the police to prevent arbitrary exercise of their power. The court stressed the need for objective standards and oversight mechanisms to ensure that any intrusion on privacy is justified. It asserted that surveillance and domiciliary visits can only be justified if conducted under a specific law with adequate safeguards in place. The ratio decidendi of the case emphasized on the importance of procedural safeguards, objective standards, and justifiable state action when limiting the right to privacy. The most interesting aspect of the case was the dissenting opinion of Justice Subba Rao. The total bench was composed of 6 members, out of whom Justice Subba Rao had a dissenting opinion which is of particular importance. Justice Subba Rao not only agreed to hold Section 236B unconstitutional, but also did the same for the entire regulations on the basis that it inherently was against Article 19 and Article 21. The view held by Justice Rao was forward-looking. He understood the fact that the petition raised questions that would have far-reaching effects. He considered the possible expansion of the meaning of life given in Article 21. To that purpose, he brought to light the case of Mun versus Illinois 1876, which defined life as not mere animal existence. Further, he illustrated how, in the case of Bolling and Sharp 1954, the offense against liberty was not simply restricting the body of a person but also confining the full range of actions. These actions are important for life. In his dissent, he further added that as civilizations progress, there must not be a narrow understanding of a person's liberty, because society moves away from mere physical restrictions to mental fears and grievances that may be conditioned by the actions such as those that the UP police was performing against the petitioner. As discussed in the Wolf versus Colorado 1949 case, surveillance of a person's private life restricts his liberty to a great extent than simply imprisoning him as a person. According to Justice Rao, the application of security against the arbitrary intrusion by police on a person's privacy has as much application to Indian jurisprudence as it does to its American counterpart. The case of Kharak Singh acted as an effective precedent for promoting the right to privacy. In Govind versus State of Madhya Pradesh 1975, the regulations similar to the UP police regulations were challenged by the petitioners on the grounds of being unconstitutional and against the right to privacy. In this case, the court upheld the regulations and the accompanying domiciliary visits and picketing that the Madhya Pradesh regulations provided for. Now we come to the conclusion of the case. The judgment in the Kharak Singh case marked the first time the Supreme Court of India in relief granted the right to privacy, although the court did not acknowledge it as a fundamental right. It laid the foundations for subsequent cases that strengthened the right to privacy and set limit on state surveillance. The decision also emphasized the importance of procedural safeguards and the need for any intrusion on privacy to be based on objective standards rather than subjective satisfaction. This later led to the establishment of the principle that the right to privacy is fundamental and should only be restricted through procedures established by law. Hi, I am Vishwajit and you are watching Landmark Cases.